Okay, we're talking about de facto courts today, and part of the reason all courts are de facto, and the reason they're de facto, we need to understand why they're de facto, and so we're going to go into a couple definitions here. First of all, de facto means actually in Latin it means in point of fact, um, but it's actual existing a fact having effect though not formally or legally recognized. Um, and the definition, the second definition is illegitimate but in effect, and I think that's probably a more correct one. That's taken from Black's Law Dictionary, 8th edition, and then it also says to look at de jure. So we'll go look at de jure too. And de jure is as a matter of law, existing by right or according to law. Okay, so these are real de jure, lawful de jure courts, and if they were de jure. And that's also Black's Law Dictionary, 8th edition. So, anyways, we need to understand a little bit some basis of knowledge here before we get into why these courts are de facto. But so every citizen and freeman is endowed with certain rights and privileges to enjoy which no written law or statute is required. These are fundamental or natural rights recognized among all free people. And so again, this is because of common law, and so at common law, you don't need a statute to give you rights. Matter of fact, statutes actually limit your rights. And so there's no written law. We have unlimited rights. And that's why the courts also rule that when a judge is operating, representing a statute like the Canada Border Pigs and their whore, in my case, which was representing a statute, the Canada Customs Act, the Canada Firearms Act. They're not operating as a judge, okay, and so they're a clerk. They're working for the agency. It's a kangaroo court, and the reason that those are in place is because I don't need a statute to give me my rights. My rights are given me by God. That's the reason God is in the Constitution, is because my rights come from God, and if God is my rights come from God, then only God can take them away. And what these criminals try and do is convert your rights into privileges, so then they can take them away, or they can assault you based on some sort of their code rules and regulations, and this is what these Canada Border Pigs did, and then they're judicial whores, which are not really judges, they're clerks, masquerading as a judge. So they're an imposter under the Vatican's Roman civil law, and so it was all just a big charade, nothing but a bunch of thieves. And I'm looking forward to justice. We're going to get some real justice here one of these days, and so, anyways, let's keep moving. As a general rule, men have a natural right to do anything which their inclinations may suggest, if it be not evil in itself and no way impairs the rights of others. And again, that's at common law. That's right. That's natural rights, and you can do literally anything you want as long as you don't damage someone else's person or their property. Mark Passio has a great YouTube presentation about natural law, and the guy's brilliant, former satanic priest, and he goes through what natural law is all about. He had to learn Latin when he was in high school, and so he goes through the derivative of these words. Anyways, in order to understand why courts de facto, we need to understand the nature of our common law de jure, our de jure, lawful de jure common law court. And so this is a case that talks about the judicial power is the power to hear those matters which affect life, liberty, or property as citizens of the state. So again, that's the jury, okay? And the jury is where our power is at, or our authority. There's a lot of cases that talk about jury nullification. There's an organization called the Fully Informed Jury Association that's been trying for many years, even decades, to educate potential juries about their rights and duties under the law. And this is one of the court cases. The common law right of the jury to determine the law as well as the facts remains unimpaired. And there's lots of cases that talk about it. And so the jury, and when they're talking about determining the law, they can say that this is a stupid law, so we're just going to ignore it. or they can say that this is a statutory matter and this guy is common law, and so statutes don't apply to living souls. And I mean, they can do literally anything they want. And jury nullification, that's what it's called, jury nullification, because they can say this is a stupid law and we're just going to find them not guilty. And that's exactly what they do. Um, the very meaning of sovereignty is that the decree of the sovereign makes the law. And that's a U.S. Supreme Court case. Um, and if the decree of the sovereign makes the law, then who is the sovereign? And we're going to find out that it's we the people, and it's we the people, especially when we are a common law jury and we issue a order. I mean, that makes law. And if the real law in this world is 800 years of jury trial decisions in Old England, and that's what the real law is. And there's really only 4 law schools that teach real law, and they're all located in the city of London. Inns of Court is one of them. And all the rest of the law schools around the world teach procedure. And so we have to understand that because that's what the real law is. It's we the people making decisions, and we can do literally anything we want, and um, literally anything we want. Um, we the people make the law. There's a principle of law called stare decisis. It's the doctrine of precedent under which it's necessary for a court to follow earlier judicial decisions when the same points arise again in litigation. The rule of adherence to judicial precedents finds its expression in the doctrine of stare decisis. This doctrine is simply that when a point or principle of law has been once officially decided or settled by the ruling of a competent court in a case in which it is directly or necessarily involved, it will no longer be considered as open to examination. And that's taken from Black's Law Dictionary, 8th edition. And now you have to understand what they're saying here. If you read these court cases, you read any court case and it'll basically say that, well, in this case, this is what happened. In this case, this is what happened. In this case, this is what happened. And these cases are all similar to this case. And so this is my ruling that this case is similar. And so I got to follow these other cases. And so if you follow that back, okay, then you go to those other cases and it'll say, well, in this case, so everything they did today is based on what they did yesterday. And that's the reason why the older the precedent, the more powerful it is. And so everything they did today is based on what they did yesterday, and then everything they did yesterday is based on what they did the day before. And so you follow these cases, and it'll go back, and it'll always go back to a jury. Okay, the only things that may not go back to a jury is admiralty, because admiralty is contract law, and so then it's up to the contract. The contract can do. I mean, you have the unlimited right to make contracts, and so that's why these bankster thieves want to set up these fictitious corporate entities and force them into bankruptcy, because then they can bring this admiralty jurisdiction, which is contract law, and enslave everybody. We the people make the law. Another principle is called res judicata, is a thing to adjudicate it. An issue has been definitely settled by judicial decision. That's not in a particular issue. A good example of that would be, for example, if I was to do a divorce. I have no interest in doing a divorce, but if I did, what I would do is I'd go to the Bible, and the Bible says that if you're not happy with your wife, then give her a writing of divorcement. So that's what I would do, is I would make up a divorce decree, and I'd say basically you're free to go and marry some other man, and get it notarized and record it in the county recorder's office, and then I'd serve it on the court and on my wife, and I'd say this is res judicata, it's already decided, and it would be, and you basically take away the jurisdiction from them because they don't have any authority to adjudicate it. So what is a sovereign? A sovereign is a chief ruler with supreme power. A king or other ruler with limited power and action is not maintainable against a foreign sovereign. And this is one of the things that we need to understand, is that, and we're going to talk about this some more, is that we shouldn't be in their courts, okay? And that's why even their courts say that they cannot do anything to us because we're sovereign. Sovereignty is the right to govern. A nation or state sovereign is the person or persons in whom that resides. That's Chisholm versus Georgia, 1793. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form a sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of the sovereignty. And that's Dred Scott versus Sanford. That's like the mid 1850s. Um, and that's not just U.S. Okay, this is a fundamental common law principle. And here's a Canadian court case that talks about the same kind of thing, because this is common law we're talking about. The sovereign people, through their representatives, have created the court and the board, as well as the municipal council, and defined the rights and duties of each. And that's reference Casa Loma. That's in Toronto, and that's a Canadian case. And so all of this stuff is basic fundamental common law. And and then here's another Canadian case, the Parliament of Canada. This is the Lord Nelson Hotel case, which was the Supreme Court of Canada. The Parliament of Canada and the legislatures of the several provinces are sovereign within their spheres, defined by the British North America Act, but none of them has the unlimited capacity of the individual. So an individual is more sovereign than the government. And so, again, we are the sovereigns, the people. Translated into constitutional terms, it denotes that the sovereign power which resides in the people is exercised on their behalf by their representatives. This is an Australian court case. And this is another Australian court case. The powers of government in this country are derived from the people who are the ultimate sovereign. And then in a United Kingdom court case, every individual was sovereign over himself. And so, really, what we are is we're all a nation of kings and queens. But what happens is, because we get involved in what the courts view to be contracts, we get ourselves, we basically give up our sovereignty. This is actually a Lansing versus Smith, 1829, a New York court case. The people of a state are entitled to all rights which formerly belonged to the king by his prerogative. And so we're going to talk a little bit about this sovereignty stuff, but we're going to move on, because I've got a whole presentation on citizenship that we'll cover another time. This is Ohio Life Insurance Company versus DeBolt, the U.S. Supreme Court. Okay, it will be admitted on all hands that, with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective states. And so, again, we the people are the sovereign. Okay, and so we the people make the law. We the people are the law. And when we convene our common law juries, we can do literally anything we want, and we have basically abdicated our responsibility by not convening common law juries, and they know it, and that's why they're doing whatever they feel like doing, because they think that that we're asleep at the wheel, and many of us are. Common law courts. And because it brings into action and enforces this great and glorious principle that the people are the sovereign of this country, and consequently that fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined. And that's Chisholm versus Georgia, 1793. And that basically says it in a nutshell, is we should not be in those courts. Okay, those courts are not, they're not real courts. Okay, those are administrators administrating statutes. There are clerks. It's a kangaroo court. They're not interested in justice. They're interested in completing a commercial transaction. Yes, there's no doubt that some of those judges are interested in doing the right thing. But are you going to take the chance that you get a good one, or you get some thief? And most of them are thieves. And matter of fact, you know, I mean, they're all foreign agents of the Vatican, and they're all, you know, pirates and thieves. Just some of them are less as much of a thief as other ones. That's really what it comes down to. A sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And again, that's U.S. Supreme Court. In other words, we the people delegated authority to the government, and we can only delegate our authority. Okay, so I don't have authority to damage you or the guy next door. I cannot. If I go and damage him, then I got a problem. And so if I can't delegate that authority, then I can't. I should say, if I can't do that, if I can't take this guy's car and give it to the guy down the street because he's broke, then neither can the government. And so this is what we have to start understanding, is that all of this stuff is based on contracts, and they get you into these contracts that we don't know we're involved in, and they're basically thieves, and it's because of the banksters and the bankruptcy and these de facto corporations and these de facto courts. It's all because of that. It's all absolutely crucial in order for them to accomplish this stuff. And people need to wake up to what's going on, or we're going to be enslaved, and many of us already are. The courts of England will take judicial notice of the status of a foreign sovereign and will not take jurisdiction over him unless he voluntarily submits to it. A foreign sovereign brought suit to restrain the defendants from using a fund in a certain way, and the defendants set up a claim for damages. It was held that the court had no jurisdiction over such a claim. And so, again, if you establish yourself as a sovereign, they don't want to talk to you. They have no authority, and they know it. These are English court cases. When a foreign sovereign comes into court for the purpose of obtaining a remedy, then by way of defense to that proceeding, by counterclaim if necessary, to the extent of defeating the claim, that person sued may file a cross-claim for the purpose of enabling complete justice to be done. And that's English case. It is a general rule that the sovereign cannot be sued in his own court without his consent. Hence, no direct judgment can be rendered against him thereon for costs except in the matter and on the condition he has prescribed. Bouvier's Law Dictionary, Volume 1, 1897. Now, U.S. used to claim sovereign immunity all the time, and if they're going to be immune, then certainly the people are immune. And but again, it's because of these bankrupt corporations and these bankster thieves and this fictitious law that they pass, and they just shove it down your throat, and they hire low intelligence thugs that don't have any concept of what the law means, and they don't train them, and so then when people get assaulted and kidnapped, I mean, we the people need to wake up and start asserting our rights. Sovereignty is itself, of course, not subject to law, for it is the author and source of law. But in our system, all sovereign powers are delegated to the agencies of government. Sovereignty itself remains with the people, by whom and for whom all government exists and acts. U.S. Supreme Court, okay? Again, all our authority is delegated to the government. And if you think about it, if I delegate authority to someone, then I still have that same authority. And I cannot delegate authority to take someone's property and give it to a guy down the street because I don't have that authority. And so neither does the government. The only reason they do it is because it's all by consent. There's a contract, and the Declaration of Independence even talks about taxation without our consent. No action can be taken against a sovereign in the non-constitutional courts of either the United States or the state courts, and any such action is considered a crime of barratry. Barratry is an offense at common law, and that's why these Canada border pigs, there is no way that they would ever grant me common law remedies, because they're nothing but a bunch of thieves, and they know it. And so they were imposing their statute. They didn't have a shred of authority. I told them about it. I've been telling them about it for years, but they don't care. And the judicial whores and Elizabeth the bitch knows all about it, and so does Johnston the pig, and Ethel the pig, and Harper the pig, and Rook the pig, and all of these whores and pigs that are in the so-called government, which is really just another bankrupt corporation in Canada, are doing this stuff. A court, the person in suit of the sovereign, the place where a sovereign sojourns with his legal retinue, wherever that may be. A court is an agency of the sovereign created by it, directly or indirectly under its authority, consisting of one or more officers established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights, alleged violations thereof, and of applying the sanctions of the law, authorized to exercise his power in a course of law at times and places previously determined by lawful authority. That's taken from Black's Law Dictionary, 4th edition. Courts, the king's palace or mansion, but more especially the place where justice is judicially administered. And that's taken from Coke as commentaries on Littleton. Um, and it says, this is Tomlin's Law Dictionary, 1835 edition. A court of record is that court which hath power to hold plea according to the course of common law of real, personal, and mixed actions where debt or damages 40 pounds or above. Um, and this is Tomlin's Law Dictionary again. Court not of record is where it cannot hold plea or, of debt or damages, but of pleas under that sum, 40 pounds, or where proceedings are not according to the course of common law. And so, again, that's what these pigs in their kangaroo court in Lethbridge, it was a kangaroo court. And so there's two kinds of courts. Generally speaking, there's two kinds of courts. There's superior courts with general jurisdiction, and there's inferior courts with limited jurisdiction. And so the way you tell the difference is that the statute, if there's a statute, a lot of these courts have a statute, but if you read the statute, it'll tell you if there's any limited jurisdiction. Okay, in other words, it'll say the court can't deal with this problem or the court can't deal with this problem. Well, that's by definition an inferior court. And a superior court of general jurisdiction, there will be no limits on what they can deal with. A court of general jurisdiction is presumed to be acting within its jurisdiction until the contrary is shown. So again, the court of general jurisdiction, they presume that they have authority until you tell them that they don't. And so, but the provincial court in Alberta is limited to they can't deal with certain issues, and we're going to see the parts of the Provincial Court Act that talks about it. So they had no business even taking this case. Again, it was prejudged. It was prejudged from the beginning. It was a kangaroo court. It was a judicial whore. Actually, it wasn't a judicial whore. It was a clerk operating for an agency. They're completely liable personally, and Rook and Mallory, the whores, the chief whores that are running, the ringleaders of all that organization, and Elizabeth the bitch. They're all fully aware of all of this stuff, and they're just letting it all go. Inferior courts. This is Tomlin's Law Dictionary, 1835 edition. If a part of a cause arises, we'll look at the underlined parts. If a part of a cause arises within the inferior jurisdiction and part thereof without it, the inferior court ought not to hold a plea. And an inferior court not of record, and basically this is in England again, but that's a general rule. If a part of cause arises in the inferior court and part of it not, then it shouldn't be holding a plea. And that was, I was bringing up all sorts of issues, and they didn't care. This is another, again, Tomlin's Law Dictionary. Though the king himself cannot now as anciently sit in judgment in any court upon civil causes, nor upon indictments, because here he's one of the parties, the king hath committed all his power judicial to one court or the other. It is enacted that all persons shall receive justice in the king's courts, and none take any distress by his own authority without a ward of the king's courts. It is said the customs precedents and common judicial proceedings are of a court are a law to that court. Okay, so and this last sentence, it says it is said the customs precedents and common judicial proceedings of a court are a lot of that court. They're talking about the rules, and so the rules are a lot of that court. So there's a couple different jurisdictions. There's actually 3 different jurisdictions that you're going to deal with. Admiralty and equity are both very similar, especially because of the bankruptcy. And then there's common law. Now, it's all determined by your pleadings and what you say, and it depends on who's bringing the case and the nature of the case. But again, it comes down to the pleadings and what you say. Equity is statutory because of the bankruptcy. Because under equity, normally equity is supposed to follow common law, but because of the bankruptcy, there is no common law in that jurisdiction, and so therefore they can do anything they want. And this is the Alberta Judicature Act. In all matters in which there's a conflict or variance between the rules of equity and common law with reference to the same matter, the rules of equity prevail. And so, again, that's what they're saying, is that there's a conflict between equity and common law. Equity prevails. A good example of that is, for example, the bankster thieves try and steal your house. Then that's the bankster thieves have an equitable interest in the property. You have legal title. They have an equitable interest. That's all they have. That's what a mortgage is. And so um, what they'll do is because of this section, then it's automatic. If the bankster thieves bring an action in the courts, then it's a foregone conclusion they're going to win. Um, and the only way that you can even hope to prevail against the bankster thieves is to bring the action yourself and claim fraud. And so then, again, by you claiming fraud, you're appealing to the equity of the court too. And so, but that's what you have to do, and that's the only way you can do it. And so there is no common law in that proceeding. There will be no common law. The Admiralty from the highest antiquity has exercised a very extensive criminal jurisdiction. Admiralty courts have jurisdiction over contracts and torts and other special cases. And so, again, Admiralty is all about contracts, and that's how you get in there. It has to be a contract. Informations are filed in the Court of Exchequer for forfeiture upon seizure of property for breach of laws of revenue, impost, navigation, and trade. And that's what the Canada Border pigs did against me. It was an information, and so it was all a kangaroo court. There was nothing common law about it. They refused to grant me any common law remedies. Of course, they didn't want to have any common law jury hear that stuff because it wouldn't fly for a second. An information is a written accusation of a crime made by a U.S. attorney or a Canada pig, which permits the government to prosecute an individual without benefit of a grand jury indictment. Of course, they don't want to have all these little technical issues about having to deal with common law. I can't have that. An indictment is required in any case where a person is being charged with an infamous crime. The Supreme Court ruled in Macon versus United States that any crime for which punishment is in prison is an infamous crime. In short, prosecutions by information have long been a political means of political suppression and intimidation. The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the crown. And that's Blackstone actually said that in Book 4 of his Blackstone Commentaries on the Laws of England. The oppressive use of this mode of prosecution by information occasions struggles to procure a declaration of its illegality. Well, they still do it. They do it in the U.S. They do it in Canada, and which basically shows. I mean, anytime there's an information, it's not common law. So that's the argument: is where's the contract here? And you're a clerk, they're a judge, and you're working for the agency, and you don't have a shred of immunity. That's where I'd be going with it. The right to be represented exists only in a military courtroom. That's Title 10, United States Code, Section 838. Again, this is a statute, okay? And so, again, if you're in a military courtroom, then that's all statutes, and then the judge in there is a clerk. All forms and modes of proceedings and causes of equity and admiralty and maritime jurisdiction shall be according to civil law. Okay, well, and think about this. Okay, admiralty, equity, maritime is under civil law, and civil law is just another name for Roman civil law, and we're going to see that. So all of these are it's all basically Roman civil law. It's all coming from the Vatican. That's U.S. Supreme Court too, by the way. Brown, Volume 2, 100, lays down the rule in these terms. The general rule, however, at present is that the Admiralty acts only in rem, that no person can be subject to that jurisdiction but by his consent, expressed by his entering into a stipulation. Okay, a stipulation's a contract. Okay, that's exactly it. Admiralty only deals with subject matter, and you cannot be subject to that jurisdiction except by a contract. They gotta develop some contract, some evidence of a contract, and that's exactly what they do. They're fabricating evidence of a contract. Anytime you're in there, kangaroo courts, that's the first thing they do is they're developing evidence of a contract, and that judge is a clerk, and he's not it's a kangaroo court. In Krebel's reports, quoted by Browns, expressly said that without a stipulation, the Admiralty has no jurisdiction at all over the person. Stipulation, a contract. That's exactly what it is. Again, U.S. Supreme Court. It is well known that in civil cases in courts of equity and admiralty, juries do not intervene, and that courts of equity use a trial by jury only in extraordinary cases to inform the conscience of the court. So have you ever wondered why the judge can sit there and ignore what the jury says, or override what the jury says, or why the judge gives the jury instructions? Well, it's because it's not common law. Okay, that's exactly why. If there's a jury there, then it's equity, and equity can do anything it wants because there's no common law, and and in admiralty there's no jury at all, and it's a tribunal. That's what exactly what it is. It's a tribunal. That's admiralty. There must be uniformity in maritime law, and the principles of maritime laws are applicable to commercial law. Therefore, there must be uniformity in commercial law. So what they're saying is maritime law is the same as commercial law. And so again, this is U.S. Supreme Court, and think about it. I mean, this kind of sounds like the great whore that rises out of the ocean, right? A whore is someone that's illegitimate, that's sold themselves. It's in Book of Revelations, and and uh, sold themselves, and admiralty, maritime law, and commercial. I mean, hello, this is what it's all about. This is Black's Law Dictionary, 4th edition. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence. And then it says that it's more properly called municipal law. So municipal law, Roman civil law is all the same stuff. And the UNIDROIT website under the UN, they have jurisdiction over municipal law. And so this is all coming from the UN. Admiralty law, the terms admiralty and maritime law are virtually synonymous. Black's Law Dictionary, 6th edition. Civil law is that rule of action in which every particular nation, commonwealth, or city has established peculiar itself, more properly distinguished by the name of municipal law. That's an English law dictionary. The technical niceties of common law are not regarded. A jury does not figure ordinarily in the trial of an admiralty suit. The verdict of the jury merely advisory and may be disregarded by the court. The rules of practice may be altered. Yeah, let's make up the rules as we go along. Whenever found to be inconvenient or likely to embarrass the business of the court, yeah, we wouldn't want to have anything embarrassing going on. Matter of fact, why don't we just have a lynching? The Court of Admiralty acts upon equitable principles. A libel of information does not require all the technical precision of an indictment at common law. If the allegations describe the offense, it's all that's necessary, and if it's founded upon a statute, it is sufficient if it pursues the words of the law. And so what they're saying is that it's a kangaroo court, and it has nothing to do with justice. It has everything to do with a commercial transaction, and they're nothing but a bunch of thieves. When they're dragging you in there based on some contract, and this has been going on for a long time. The causes and necessities of taking up arms in 1775 even talks about it, and that's what this is. Statutes have been passed for extending the jurisdiction of the courts of admiralty and vice admiralty far beyond their ancient limits, and for altering fundamentally the form of government established by charter, and we saw the misery to which such despotism would reduce us. So what they're essentially saying is that they're using this admiralty and vice admiralty jurisdiction to form a military dictatorship. And that's what a despotism is. And you think that's going on today? That's exactly what's going on today. Equity in the early history of the law, the sense affixed to this word was exceedingly vague and uncertain. This is owing in part to the fact that the chancellors of those days were either statesmen or ecclesiastics, perhaps not very scrupulous in the exercise of power. It was then asserted that equity was bound by no certain limits or rules, and that it alone was controlled by conscience and natural justice. And that's citing Blackstone, and that's in Bouvier's Law Dictionary, 1856 edition. Equity, a court of equity, is one which administers justice where there are no legal rights or legal rights, but courts of law do not afford a complete remedy, and where the complainant has an equitable right. Okay, that's a good example of that is the banks are thieves in a mortgage. Equity, the system of law or body of principles originating in the English Court of Chancery, superseding the common law and statute law, together called the law in the narrow sense. When the two conflict in appealing to the equity of the court, she's appealing to the king's conscience. Okay, so she's essentially asking for the court to do the right thing, and so the court has the power to do that under equity. This is Black's Law Dictionary, 7th edition. Common law doesn't provide a very good remedy sometimes, or statute law, and so the court can kind of bend the rules under equity. And normally it's supposed to follow common law, but when the government's bankrupt, when we talk about the martial law video and the bankrupt corporate governments video, when the government's bankrupt and it's all martial law, and there's no common law in that jurisdiction. And so you cannot go in and argue common law or expect a common law remedy, because it's not going to happen. That's exactly what happened with the pigs at the border. They're just nothing but a bunch of thieves. And laches is an equitable principle, okay? Unreasonable delay in pursuing a right or claim, almost always an equitable one, okay? The equitable doctrine by which a court denies relief to a claimant who is unreasonably delayed in asserting the claim, when that delay was prejudiced the party against whom relief is sought. Yeah, these pigs don't want to be held responsible for their stuff, so that's the first thing they're going to say is, oh yeah, shoot, it's been 10 years since this issue happened. And so they're essentially saying, they're asking the court to basically dismiss it because they've been asleep on their rights. And this is Black's Law Dictionary, 8th edition. It is a rule of common law. The reason applies in equity and other civil law cases, that if a party can plead a fact material to his defense and omits to do it at the proper time, he can never avail himself of it afterwards. And that's Penhallow versus Doan's Administrators. And that's basically talking about jurisdiction, but I mean, everything is especially jurisdiction, but everything is, you have to plead it at the proper time. And that's why when I sued the IRS thieves, and right from the beginning, I said, so where's your authority? Where's the contract here? And, you know, of course, they didn't want to talk about that, and it wound up to the Supreme Court. And when, by the time I got to the Supreme Court, I said there is no contract. They've had plenty of opportunity to produce it. And if anybody has any doubt that I've been to the Supreme Court, go and look it up at the Supreme Court's website. You'll see it there. And so, anyways, jurisdiction must be raised before making any plea to the merits, if at all, when it arises from formal defects in the process or when wanted jurisdiction over the person. So you got to challenge that right up front, okay? That's a Supreme Court case. If the common law can try the cause and give full redress, that alone takes away the admiralty jurisdiction. In Credible Reports quoted by Brown, it is expressly said that without a stipulation, the admiralty has no jurisdiction. The common law is the standard by which to ascertain what proper cases of a prohibition of court admiralty, and not the civil law. And again, that's why they want to get that bankruptcy, because then that gets rid of the common law, and then all they can just do anything they want. That's what these bankster thieves do. And let the cases be searched from the remotest period down to the time of Minotone versus Gibbons, to the ground of prohibition and of recovery under the 2nd of Henry IV, will uniformly be found to be the competency of the common law to enforce the contract. This is the principle by which even their jurisdiction in rem is controlled, and it hence follows that in no cases in which they are prohibited from proceeding in rem can they have the action in personam. But they do it all the time, again, because there's no common law, and because of the bankruptcy. And when acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension of an agent for the involved agency, but only in a ministerial and not a discretionary capacity. And judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. It is accepted rule that not only state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for the agency. So again, these judges, there's no judges, okay? There is not a judge in the country, in the US or Canada. It's all statutory, and they're all a bunch of clerks putting on this masquerade that they're imposters. That's exactly what there are, and they're thieves, and they're pigs, and don't get me going. And these whores that I was dealing with in Canada, that they fit the bill perfectly. There are no judicial courts in America. They have not been since 1789. Judges do not enforce statutes and codes. Executive administrators enforce statutes and codes. There have not been any judges in America since 1789. There have just been administrators. Now, you know, you go and file an action in federal court, and unless it falls within those criteria that the statutes, their color of law statutes, say that they can accept these statutes, these lawsuits under, they'll dismiss it because they don't have jurisdiction. All of these federal judges in the U.S. are statutory. The state judges are the same. It's all coming from the UN. There's no judges in America, Canada, or U.S. And you know, I haven't done any research in Mexico or any of these other places, but it's probably the same there. There's no judges. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessary nullities. Okay? It's void. It's a fraud. They're nothing but thieves. Even the U.S. Supreme Court operates under the authority of the President of the United States. This is Rule 45.1 of the U.S. Supreme Court Rules of Procedure. And it says, all process of this court issues in the name of the President of the United States. Okay? So, you know, think about it. What happened recently with that Obamacare? Okay, what happened was there was a U.S. Court of Appeals judge, I think it was like the Fifth Circuit or something, that was railing on some U.S. attorney. It was all over the news about this Obamacare. And the next thing you know, Obama comes out and starts tearing a strip off the U.S. Supreme Court. And then the next thing you know, when the Obamacare case goes to the Supreme Court, they caved in big time. They saw what they had to do. They are following instructions from their handler. That's exactly what's going on. There's no common law judicial immunity, but they're not judges, so there's no immunity anyways. And that's the argument to bring up when you're dealing with these pigs. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. When any state proceeds against a private individual in a judicial forum, it's well settled that the state, county, municipality, etc., waives any immunities to counters, cross claims, and complaints by direct or collateral means regarding the matters involved. And so these pigs in Canada, it's coming back around at them one of these days. And it may not happen today, it may not happen next week, but it's coming back around. And I'm going to see some of these pigs do that little dance they do at the end of a common law rope. It's one of the fundamental maxims of the common law that ignorance of the law excuses no one. It is a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. There are no judges. Immunity for judges does not extend to acts which are clearly outside their jurisdiction. A libel in spiritual court, okay, you got to understand what this is saying. This is Jacob A. New Law Dictionary, 1750. Okay, a libel is spiritual court, okay? This is coming from the Vatican. Okay, admiralty is a libel is how you file an admiralty proceeding. They've gone and made it all the same, but the bottom line is it's still a libel, and a libel is done in spiritual court. If a libel for any ecclesiastical matter, the defendant make a surmise in BR to have a prohibition, and such surmise be insufficient, the other party may show it to the court, and judges will discharge it. Remember, discharge, okay, this is all commercial. The libel is used in ecclesiastical proceedings, consists of 3 parts, and it talks about the libel. A libel is defined as a plaintiff's petition or allegation made and exhibited in a judicial process with some solemnity of law. It is also said to be a short, well-ordered writing, setting forth in a clear manner, as well to the judge as the defendant, the plaintiff's or accuser's intention and judgment. It is a written statement by the plaintiff of his cause of action and of the relief he seeks to obtain in the suit. And that's a cite from Law's Ecclesiastical Law, okay? A libel is coming from the Vatican. Admiralty Maritime Law, Roman Civil Law, this is all coming from the Vatican. And this is actually cited in Bouvier's Law Dictionary, 1856 edition. Color signifies a probable plea, but which is in fact false. And that's Tomlin's Law Dictionary, 1835. Color of law is when an act is evilly done by a countenance of an office, and always taken in the worst sense, being grounded upon corruption, to which the office is a shadow and a color. And that's Tomlin's Law Dictionary, 1835 again. Color, an apparent or prima facie right. Okay, we're talking about the appearance. To give color is to admit such a right. Color is 2 kinds, implied or express. And so, again, it's a fraud. Implied color is that which naturally inherent in the structure of all pleas in confession and avoidance. That is, that they admit a right in the opposite party, but at the same time avoid it. Express color is defined to be a feigned matter pleaded by the defendant in an action of trespass from which the plaintiff seems to have a good cause of action, whereas he has in truth only an appearance or a color of cause. And that's Burl A. Lou Law Dictionary, 1871. Again, it's a fraud. Extortion uh, is a large sense any oppression under color of right. Okay, it's usually applied to that abuse of public justice, which consists in the unlawful taking by an officer by color of his office. That's what the Canada Border Pigs did. Of any money or valuable thing from a person where none of all is due. That's again the Canada Border Pigs. That's Tomlin's Law Dictionary, 1835. A bull, a brief mandate of the Pope or Bishop of Rome that all bulls, briefs, dispensations had or obtained from the Bishop of Rome should be void. If any person shall obtain from Rome any bull or writing to absolve or reconcile, such as forsake their due allegiance, or shall give or receive absolution by color of such bull. Okay, anything of this, it's all a fraud. Tomlin's Law Dictionary, 1835 edition. It's all coming from the Vatican. When I went and I filed a petition, or actually it's a lawsuit in Texas court, and against, I won't say who it was against, but they went and the respondent went and removed it in the federal court, and I didn't want it in there, and so I went and I figured the judge is going to dismiss it anyways, so I just dumped on the judge. I called him a judicial whore. I told him he had an inferior court of limited jurisdiction, and I told him that I had nothing but contempt for his so-called court, and I called him a whore, and I demanded that it get removed into state court. Oh, another thing I told him, which is relevant right now, is I told him everything he does is fraud, and I said, and all of his orders are brutum fulmen. Okay, brutum fulmen means an empty noise, and I felt guilty afterwards because he came back and he was nice. He said I'd made some false accusations. Yeah, I felt guilty. But the bottom line is that it was 100% right, and he knew I was right, and ultimately he dismissed the thing because I kept getting belligerent. But he dismissed it without prejudice. Okay, and what that means, they can dismiss it without prejudice or with prejudice. If they dismiss it with prejudice, they're basically saying you cannot bring this action again. But he dismissed it without prejudice and basically said that if I wanted to be more respectful to the court, that I could bring the action again. And so, anyways, again, everything they do is a fraud. Fornication, whoredom, act of incontinency between single persons, or if either party be married, it's adultery. The first offense is punished with 3 months imprisonment. The second made by felony, and in late times of usurpation by a pretended act made in 1650. Okay, this is Cowell's Law Dictionary, 1708. So this pretended legislation, okay, is fictitious law. It's color of law, and the Declaration of Independence even talks about it. Here's another Jacob A. New Law Dictionary, 1750. No judicial proceedings commenced or prosecuted in the style of, so they're talking about this, and a pretended act of Parliament for turning the books of the law and proceedings of courts of justice into English was declared to be enforced. Okay, so in other words, what they do is they'll say this act is enforced even though it's not a valid act, and the courts have to go along with it unless you bring it up. Okay, unless you bring it up. If you bring it up, then everything changes. But until you bring it up, they'll presume that it's a valid act and they'll railroad you based on it. And I challenged the pigs at the border with their Customs Act. Matter of fact, it's well documented in the lawsuit that I filed 3 years ago in 2010. But they're just nothing but a bunch of thieves. Jesuits born in the king's dominions and are ordained by the pretended jurisdiction of Rome. Okay, again, it's all coming from the Vatican. That's Jacob A. New Law Dictionary, 1750 edition. And so again, anything with this pretended legislation or color of law, this fictitious everything is all coming from the Vatican. That's exactly where it's coming from. He's combined to others to subject us to a jurisdiction foreign to our Constitution, acknowledged by our laws, giving his assent to their acts of pretended legislation. This is taken from the Declaration of Independence, and if you understand what the Declaration of Independence is, it's basically a list of grievances. And so acts of pretended legislation. They're talking about it in the Declaration of Independence. And here's some other issues. It's a list of grievances. He's affected to render the military independent of and superior to the civil power. Gee, that sounds like martial law. For imposing taxes on us without our consent. Gee, that sounds like martial law. For depriving us in many cases of the benefits of trial by jury. Gee, that sounds like martial law. For abolishing the pre-system of English laws in a neighboring province, therein establishing an arbitrary government. Gee, that sounds like martial law. And enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. Gee, that sounds like martial law. He has abdicated government here by declaring us out of his protection and waging war against us. Gee, that sounds like martial law. And protecting him by a mock trial. And that's all taken from the Declaration of Independence. This is all coming from the Vatican. This is Tomlin's Law Dictionary, 1835. And so these whores that are up there masquerading as a judge are really just clerks, and they're conspiring with this agency in open court to railroad you. That's exactly what's going on. And so they're imposters. Those who falsely pretend an extraordinary commission and or terrify and abuse people with false denunciations of judgment. And that's exactly what it is. It's a void judgment in my case. They're nothing but thieves, and don't get me going. And this is actually Williams Law Dictionary, 1816, which says basically the same thing. Burnanew Law Dictionary, 1792, and it's the same thing, and they've added in some things. If you want to read the rest of it, stop the video and you can watch it. You can read it. Imposter, one who pretends to be someone else to deceive others, especially to receive the benefits of a negotiable instrument. Well, how do you think they get paid? I don't care if they get paid cash. I guarantee you it's a negotiable instrument. Matter of fact, they cannot deal in lawful money. And that's Black's Law Dictionary, 8th edition. There's 358 court cases at Canley that say that they have to have the appearance, of justice. And if you go to justia.com, you'll find even more. The appearance of justice is not justice, but is a fraud. Prima facie is at first sight, on first appearance, on the face of it, so far as can be judged from first disclosure. Presumably, a fact presumed to be true and must disprove by some evidence to the contrary. So think about it. They're bankrupt, so they're busy to make money for their handlers. So they presume everything for their handlers so they can make money for their handlers. And if you don't know the law, then you're going to get railroaded so their handlers can make some money. And that's exactly what's going on. Colorable, presenting an appearance does not correspond with reality. An appearance intended to conceal or deceive. This is Barron's Law Dictionary, Canadian one. And color of law, mere semblance of a legal right and action done under color of law is done with apparent authority. Gee, that sounds like an appearance. It may still be legislating effects. This is Unemployment Insurance Act of 1937 when the Privy Council overturned it. And there's a couple points I want to make here. It says, in other words, Dominion legislation, even though it deals with Dominion property, and so what they're saying is their statutes only deal with their property. It has nothing to do with we the people. And also it goes on, it's not necessary there should be a colorable device or a pretense. In other words, they're giving them the recipe, and they made it color of law, and that's what they did. This is the Privy Council overturned the Unemployment and Social Insurance Act in Canada in 1937, and so then they just passed it again, and they made it color of law. Color means an appearance, a semblance, as distinguished from that which is real, a prima facie or apparent right. Hence, a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext. Colorable means that which is in appearance only, but not in reality what it purports to be. Hence, counterfeit, feigned, having the appearance of truth. It's a fraud. Color of law means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law, made possible only because wrongdoers clothed with authority of state is action taken under the color of law. It's a fraud. Everything they do is a fraud. Color signifies a probable P, but which is in fact false. It's a fraud. It's a lie. Color of law. When an act is evilly done by the countenance of an office, always taken in the worst sense, being grounded upon corruption. Well, no joke. I've heard of cases that were dismissed because they were not colorable enough. which means that there was not enough fraud in it. Everything else, everything these de facto United Nations so-called courts do is a fraud. They cannot proceed unless the pleadings are full of fraud. A statute, and let's look at the underlying part too. Statutes enacted in Parliament, there must be the assent of the King, Lords, and Commons, without which there could be no good act of Parliament. And so, again, unless they got all of this stuff there, then it's not an act. And yet it also says, but there are many acts in force, though these three assents were not mentioned therein. In other words, there's all sorts of them that are color of law. And then another interesting point, it says concerning sheriffs is a private act. And so that's Burney New Law Dictionary, 1750 edition. Capitis diminutio is the destruction of legal personality. Capitis diminutio wipes out the former individual, puts a new one in his place. Um, and so then there's different kinds of capitis diminutio. Oh, it's interesting if you look at point one there, juristic personality may thus be destroyed in one of three ways: by loss of status libertatis. This is capitis diminutio maximus. Okay, in other words, that's a slave. By loss of status, it's all about status. That's the important thing to understand. By loss of status cavitatis. This is the capitis diminutio media, and by severance from the agnatic family, this entails capitis diminutio minima. And so, again, a capitis diminutio maxima is the Roman, the minutia of a person's legal status as a result of being reduced to slavery. Black's Law Dictionary, 8th edition. Capitis diminutio in Roman law, diminishing the abridgment of personality, loss or curtailments of a last man's status or aggregate of legal attributes and qualifications. Maxima is when a man's condition was changed from one to freedom to one of bondage when he became a slave. It swept all away all rights of citizenship and family rights. Black's Law, 4th edition. And status, laws of status, it has to do with Roman civil law. This is all Roman civil law. Now, that's one of the things. It's one of three departments in which civil law is divided, which is status, and that's taken from Black's Law Dictionary, 8th edition. And so, this is what we have to understand. This is all Roman civil law. There's two kinds of jurisdiction. There's in rem and in personam. In rem, this is taken from Rapalje, Dictionary of American and English Law, Volume 1, 1883 edition. In rem, with regard to conclusive effects, judgments are two kinds, in rem and in personam. In rem, a judgment in personam is an adjudication pronounced upon the status. It's all about status. So this is all Roman civil law. Matter by a tribunal having competent authority for that purpose, okay? And so, again, this is Roman civil law, and it's a tribunal, okay? And so that's why we don't want to have, we want to have our lawful de jure courts. Are we going to go and trust one of these whores, the clerks, that's going to just basically just, that's working for the agency, not interested in justice or anything resembling justice, to complete his commercial transaction? And so anyways, says here that such an adjudication being a solemn declaration from the proper and accredited quarter that the status of the thing adjudicated upon is as declared, okay? So again, it's all about status. And that's in rem jurisdiction or in personam jurisdiction. It's all about status again. A judgment in personam is more accurately called a judgment inter partes for an adjudication upon the status of a particular person and adjudication on the status of a thing, okay? So again, a person is a thing. And that's, again, they want to fabricate evidence of a contract. That's exactly what they're doing, and that's what it's all about. Judgment of a non-suit is where a plaintiff fails to appear in a trial or throws up the action. Like a judgment by default, it may be set aside on such terms as the court thinks, and it's also could be a discontinuance. Removal and enforcement of judgments, and so a judgment may in some cases be enforced in other courts than it was originally given. Thus, a judgment in a county court or other inferior court may in certain cases be removed into the higher courts. And so again, that's what removal is. In personam, in rem, So a judgment or decree is said to be in rem when it binds third persons. Okay, and the reason I'm bringing this up is because Court of Admiralty deals with marriage. Marriage is completely admiralty. Court of Admiralty on a question of prize or a decree of nullity or dissolution of marriage. That's all admiralty. No person is eligible to be appointed. This is the Canada Judges Act. No person is eligible to be appointed a judge of a superior court in any province, and except that they've been a bar member for at least 10 years. And um, so you have to understand that all judges are bar members, are all foreign agents of the Vatican and Canada. Now, in the provincial court, this is a superior court, so this is Queen's Bench. It's nothing. Doesn't say anything about the provincial court here. So in Alberta courts, there's provincial courts. They have an inferior court. It's a limited jurisdiction. It's a statutory court, and it may be of record, may not. And Alberta has also got Queen's Bench, which is a superior court of general jurisdiction, and it's potentially a common law court if you can get the bought and paid for United Nations whore to honor his oath, and it's a court of record. It could be a court of record. A kangaroo court, a self-appointed tribunal or mock court in which the principles of law and justice are disregarded, perverted, and parodied. A court or tribunal characterized by an unauthorized and irregular procedure so as to render a fair proceeding impossible. Gee, that sounds like a clerk. A sham legal proceeding. Kangaroo court, the term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. And that's Black's Law Dictionary, 6th edition. A tribunal is any court that is not a jury of our peers. Tribunal is the seat of a judge, the place where he sits, administers justice. The whole body of judges who comprise the jurisdiction of judicial court, the jurisdiction which the judge exercises. These are all tribunals. That's all you'll see today, unless it's a true common law jury of our peers. And there's not too many of those things that are operating these days. Black's Law Dictionary, and certainly not put on by the government. It's got to be just private citizens that get together and do it. That's Black's Law Dictionary, 4th edition. Black tribunal comes from canon law. Tribunal is Roman law. Tribunal is the seat of judge, the place where he administers justice, the whole body of the judges who compose the jurisdiction of which the judges exercise. The term is Latin, derives its origin from the elevated seat where the tribunes administered justice. Okay, so again, this is all coming from Roman law, and it's canon law. And that's taken from Cahill, the Encyclopedic Dictionary, 1922. And this is actually taken from canon law. Tribunal is from canon law, and there it is. It's talking about different grades and kinds of tribunals. Tribunal of first instance, okay, so this is all canon law. And this is the Oath of Kol Nidre from the Jewish Encyclopedia, Volume 8, page 539. And it's also found in the Revised Festival of Prayers, published in 1919 by the Hebrew Publishing Company. So how many of these judicial whores, or clerks, I should say, are Jews? All vows, oaths, obligations, anthems, whatever, whether called Conan, Konas, or any other name by which we may be bound from this day of atonement unto the next, we do repent. May they be deemed dissolved, forgiven, annulled, and void, made of no effect. They shall not bind us, nor have any power over us. The vows shall not be reckoned vows. The obligations shall not be obligatory, nor the oaths be oaths. And then if they're not Jews, they're certainly going to be Masons. You know, most of these lawyers are Masons. And so if they're not Jews, they're going to be Masons or Jesuits, one of the three. And in my Corruption in the Courts 4, we go through the Jesuit oath. You're really going to like that. You ought to wait until you watch that one for sure, because you'll see that Jesuit oath. That's a good one. Whenever you see any of our signs made by a brother Mason, especially the grand hailing sign of distress, you must always be sure to obey them, even at the risk of your life. If you're on a jury and the defendant is a Mason and makes the grand hailing sign, you must obey it. You must disagree with your brother jurors if necessary, but you must be sure not to bring the Mason guilty, for that would bring disgrace upon our order. You must conceal all crimes of your brother Masons except murder and treason, and these at your own option. And should you be summoned as a witness against a brother Mason, be always sure to shield him, prevaricate, don't tell the truth in this case, keep his secrets, forget the important points. It may be perjury to do this, true, but you're keeping your obligations. And that's found on page 83 of the Masonic Handbook. And so And that's not. There's other things that are. This is an Encyclopedia of Freemasonry in 1916 edition, Volume 2, page 555. And the underlined part, first of all, it talks about perjury, and the underlined part says the old Romans seem to have taken a sensible view of the crime of perjury. Among them, most were not often administered, and in general, a promise made under oath had no more binding power in a court of justice than it would have had without the oath. False swearing was with them a matter of conscience, and the person who was guilty of it was responsible to the deity alone. And so, yeah, right. So those are the kinds of people we have as lawyers. You know, I can't tell you how many times I've had lawyers tell me just to make things up, and these whores that are on the bench, or I should say, these clerks that are masquerading as a judge, they're all lawyers. Oaths. And this is taken from Tomlin's Law Dictionary, 1835 edition, volume 2. All oaths must be lawful, allowed by common law or some statute if they're administered by persons in a private capacity or do not duly authorized. They are quorum non judice and void. In other words, if it's not the proper person administering the oath, then they're void. And and I'm going to show that the Queen doesn't even have an oath. So then, if she doesn't have an oath, it all flows from her, and so then none of them have an oath. Um, Elizabeth Battenberg, the bitch, Queen of Canada, has no lawful valid oath. She was not coronated on the true stone of destiny as required. And there's a website if you want to go and read that. There's about a 30-page article. It goes through and explains it. And then there's the John Anthony Hill case where he went and brought up the issue that she perjured her oath. And here's some websites that you can find it. And this is one of them right here. And let's get in closer. U.S. landmark or UK landmark case could stymie the legal system. Queen's not a valid monarch. And for those of you who've been following the John Anthony Hill case, it's great to be able to share that he was acquitted. It's interesting to note that the judge said it was irrelevant, which tells me that he knows that the oath is not valid. And number one, and it tells me, and then all of a sudden acquitted him. So it's magical how that happens. Um, this is the ringleader of the criminal enterprise called Canada. This is the bitch, and she's getting ready to kick off here pretty soon. So, but she's got lots of spawn out there that are going to follow after the traditions. All courts in Canada and the United States are United Nations courts under UNIDROIT Treaty and have been for over 30 years. All courts are de facto courts. There's no authority to delegate anything to the United Nations in the Constitution for the United States of America or the British North America Act. UNIDROIT covers negotiable instruments, civil procedures, secured transactions, legal status of women, maintenance obligations, contracts, banking law, much more. And this is the website. We'll get in a little closer. It talks about commercial contracts, cultural property, franchising. And this is the next page. We'll get in a little closer. International leasing, security interest, transport, banking law, capital markets, civil procedure, contracts, franchising, hotel keepers, insurance, intellectual property, leasing. This is all falls under UNIDROIT. Legal status of women, maintenance obligations, movement of persons. Why do you think that they spell your name in all block capital letters when you get an airline ticket? Negotiable instruments. All of these IOUs that are circulating around for money, that's all governed by UNIDROIT. UNIDROIT covers mandatory insurance for motor vehicles, anything related to marriage, divorce, and children. And this is actually another part of the UNIDROIT website. It talks about the 1955 Benelux Treaty on compulsory insurance against civil liability. So they go and manage the insurance or regulate it, and then they make it mandatory because obviously that's because it's the bankster thieves and they want to make a bunch of money. They make this insurance mandatory so then they can jack up the prices. 1958 Convention concerning the recognition and enforcement of decisions relating to maintenance obligations towards children. Where do you think CPS is coming from? That Child Protective Services scam. Okay, that's all come from the UN. And so if you think about it, this is Title 18 United States Code, Section 31. This is federal. Anything to do with motor vehicles in the states, I don't care if it's a state statute, it's still really a federal statute because it falls under UNIDROIT. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways and the transportation of passengers, passengers' property, or property and cargo. And it even goes on and defines what commercial purposes is. And so that's the only thing is you only have a motor vehicle if it's involved in commerce, and they know it, and they deliberately hire brain dead idiot thugs to go out and assault you based on for these commercial crimes. And that's exactly what they do. And there's lawsuits and court cases that talk about it. In Canada, the United States are signatories to the UNIDROIT Treaty. As of this date, 63 countries have signed the UNIDROIT Treaty, and this is from their membership part of the website. There's Australia, Canada, and there's a whole bunch of countries. There's actually 3 or 4 more pages, but this is the United Kingdom and United States. Texas is not listed. Arizona is not listed. No American state is listed. Alberta is not listed. British Columbia is not listed. Ontario is not listed. No Canadian province is listed. Therefore, anything involving motor vehicles or the courts is both commercial and federal. And so you got to understand that this is all coming from the UN. Anything in America, Canada, or United States involving motor vehicles or the courts or the banks or finance falls under UNIDROIT. And so then the Constitution is a trust indenture with delegated authority, and this is a U.S. Supreme Court case that talks about it. Governments are but trustees acting under derived authority and have no power to delegate which is not delegated to them, but the people, as the original fountain, might take away what they have delegated and entrust to whom they please. Okay, so it's talking about a trust and it's talking about delegated authority. And there's more than that case that talks about it. Here's another Supreme Court case. There's no such thing as the power of inherent sovereignty in the government. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not by their Constitution entrusted to it. So again, the Constitution's a trust indenture and with delegated authority, okay? And I set up trusts for people, so I know what a trust indenture, and it's not a corporate articles of corporation. It's nothing to do with a corporation. And the delegate cannot delegate. An agent cannot delegate his functions to a subagent without the knowledge or consent of the principal. The person to whom an office or duty is delegated cannot lawfully devolve the duty on another unless he be expressly authorized to do so. A delegated power cannot again be delegated. A deputy cannot have or appoint another deputy. Well, I don't remember, but help me out here. I don't remember seeing anything about the United Nations in the Constitution for the United States of America. Matter of fact, there's no delegated authority for a corporation called United States or any agency, department, commission, board, or entities of such corporation. And yet in Title 28 United States Code Section 3002, which is the judiciary in the United States, it says that if you're going to sue the government, then you got to sue a federal corporation or an agency, which is just another corporation, and even banks are instrumentalities of the United States. And what they do, these bankster thieves, is they put it in bankrupt so they can seize it. And it's established fact that the United States federal government's been dissolved by the Emergency Banking Act, being bankrupt and insolvent, the joint resolution to suspend the gold standard and abrogate the gold clause dissolved the sovereign authority of the United States and the official capacities of United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. And that's the United States Congressional Record, March 17, 1993. And so this all happened in 1933. There's good reason to believe that it happened in the Civil War. And so the point being is that the bankster thieves go and watch my video about bankrupt corporate so-called governments and another one about the bankster thieves, and you'll start to get the picture. And so I don't remember anything in the Constitution about a corporation called the Federal Bureau of Investigation. Help me out here. I don't remember anything in the Constitution about a corporation called the National Security Agency. I don't remember anything about a corporation called the Central Intelligence Agency or the Department of Homeland Security or the Internal Revenue Service or the Department of the Treasury or an agency called the Office of Attorney General of the United States. You know, and yet it's the same whore, this pig holder, that goes around saying that sovereigns are terrorists, you know, because that's exactly, they're making war on the people. That's what this war on terror is all about. It's a war on the people. There's no delegation of authority for, help me out. Maybe I'm missing something. Does it say anything in the federal Constitution about the city of Fort Worth or the city of Grand Prairie or any municipal corporation or any prison corporation or any corporation called Department of Public Safety in any state? I just don't remember seeing any of that stuff. Help me out here. Maybe if anybody out there knows of anything in the federal Constitution, please tell me, because I am just missing it. A corporation called Texas State Police or State Police in any state. And you think it's any different in Canada? Absolutely not. This is the bankruptcy in Canada, and this is an application for a SIN card. And it says here that if you're getting a card replacement, that you got to make a check payable for $10 to the Receiver General for Canada. Well, think about it. That's a receiver in bankruptcy. Hello. So I don't remember anything in the B&A bill about a corporation called Royal Canadian Mounted Police. Help me out here. I'm missing that. Or the Canada Border Services Agency pigs, or the Lethbridge Correctional Center, the Calgary Remand Center. I just don't remember anything in there about any of those corporations. There is no authority in Canada or the United States to delegate any power to the United Nations. Help me out. I'm looking. I'm not seeing it. Where it says anything in any one of those documents about United Nations. Help me out here. I'm trying to see it. Help me. All the so-called courts in Canada, United States, and many other countries, 63 according to the Unidroit website, are United Nations courts, are de facto, are thieves, are pigs, are pirates, and in some cases are murderers. I mean, why do you think that International Criminal Court of Justice is convicting these like Elizabeth the Bitch and the Vatican pigs? Ultra vires, an act performed without any authority on a subject. The term has broad application and includes not only acts prohibited by the Charter, but acts which are in excess of powers granted. Act is ultra vires when a corporation is without authority to perform it under any circumstances or for any purpose. Ultra vires act of municipality is one which is one beyond powers conferred upon it by law. That's Black's Law Dictionary, 6th edition. In Canada, they even passed there's a statute that says that nobody can be convicted for, because of obedience to de facto law. It says here, Section 15 of the Criminal Code of Canada, no person shall be convicted of an offense in respect of an act or omission in obedience to the laws for the time being made and enforced by persons in de facto possession of the sovereign power in and over the place where the act or omission occurs. Well, they're all de facto. They're nothing but a bunch of thieves. And I told them that 3 years ago, but they don't care. Like I said, they're thieves, and I'm looking forward to some of them do that little dance they do. You know that. And this is the Gold Reserve Act of 1934. And so it says here, Section 15, it says, as used in this act, the term United States means the government of the United States, and the term currency of the United States means United States notes and Federal Reserve notes. And so, therefore, Federal Reserve notes are only meant for internal use in the government of the United States. That is it. And if you go and use a Federal Reserve note, you're essentially saying that you're a government employee. So when these courts, they only deal with Federal Reserve notes or Bank of Canada notes. And when you use those things, they are just presuming, because they're courts and that's what they do, they're presuming that you're one of their government employees and that you're subject to all their codes, rules, and regulations. And that's what the pigs at the border did with me. And because the border pigs only have authority over government employees. This is Title 12's United States Code, Section 411, and it says that actually the pigs at the border have authority over aliens and government employees. And so, anyways, this Title 12 United States Code, Section 411, basically says the same thing as the Gold Reserve Act of 1934, and it says that the Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to Federal Reserve banks through the Federal Reserve agents as hereinafter set forth, and for no other purpose are authorized. Okay? And so they're not meant for anything but internal use of the government. When you use banknotes, you're saying you're a government employee. And so, in summary, these de facto courts have no authority. The reason they're de facto, okay, is because they have no authority. They're a United Nations court. They're not judges. They're clerks. They're working for an agency. There's nothing to do with justice that's going on in there. There's no lawful money. There's no lawful valid current of oath. It's a tribunal. It's a kangaroo court. There's no jury. And a jury is 12 living souls of our peers. Who better to judge us than those who know us? And that's exactly what a jury of our peers is. If they do have a show jury, they ignore it. Or the jury gets instructions. They tell the jury what to do. And it can be appealed. That's just more evidence that they're de facto. The officers of the court are all foreign agents of the Vatican. See the bar members video. It's nothing but a kangaroo court. And let me say here that I certainly don't want to mean anything negative towards people that happen to be Catholic. I have many wonderful friends that happen to be Catholic, and they're the ones that are telling me this stuff about the Vatican, quite frankly. And and a lot of times they're as much victims of these criminals in the Vatican as anybody. And so certainly it's no reflection upon people that happen to be Catholic. There's many wonderful people that are Catholic, and I certainly don't want to intend anything negative towards them. At common law, the jury has to be your peers. They have to know you. At common law, the jury calls the witnesses, questions the witnesses, determines the law and the facts of the matter, and even pronounces sentence if necessary. At common law, the jury can disregard the law, which is called jury nullification. At common law, the jury can do literally anything it wants. At common law, the decision of the jury is not subject to appeal. The motivation of the de facto, this is part of my Fire the Whores campaign. The motivation of the de facto so-called judges is not for justice. They're not competent to do justice, quite frankly. That's really the bottom line. They are not competent to do justice. That's why they say they have to have the appearance of justice, because they know that it's all a fraud. And this is covered in Corruption in the Courts, number 4. And they intend to create business for their so-called court, to justify their existence, to create work for their de facto buddies, to collect more royalties, to get promotion to the Court of Appeals or the Supreme Court. They create work for their buddies by making their decisions as cryptic as possible, by forcing the issue to another hearing, and by ignoring the law and thereby forcing an appeal. It's all about the business. There's a YouTube profile by a guy called Servant King, and Servant King explains how the court case is a satanic religious ceremony. Servant King explains how the court case is they're doing necromancy, which is bringing the dead to life, and that is witchcraft. Do you want to place your future in the hands of a United Nations whore who wants to sit on the bench and play stupid? That's exactly what they do. Do you want to put your future of your wife and children in the hands of one of these judicial whores who have complete immunity no matter what? Because if you sue one of them, you have to get one of their whore buddies to do it. Sure you want to get one of them? Sure, some of them could want to really do justice, but are you going to take the chance that you got a good one? And I guarantee you the amount that want to do justice is a very slim few. Do you want to place your future in the hands of a whore that is bought and paid for by these crown pigs? Do you want to place yourself in the hands of a judicial whore who's intent on converting you into a ward of the court, which is an imbecile? Do you consider yourself Christian? Do you try to follow the golden rule? Do you treat others the way you want to be treated? Do you think that you'll get any sympathy from God on Judgment Day when you've not done everything you can to put a stop to these satanic judicial whores selling their justice? You know, there's a thing, karma is the universal principle of what goes around comes around. And if we knowingly allow these judicial whores to victimize tens of thousands of people in the name of their satanic religious ceremonies, don't you think that we'll be held accountable? Don't you think it will come back around at us? Don't you think it's already coming back around at us every day when they sell their justice in their de facto so-called court, when their revenue officers are masquerading as police officers and unlawfully arrest us for commercial crimes like speeding, when they deny us due process based on one of their fictitious quasi-contracts, when they populate their prisons with victimless crimes? All of these judges are foreign agents of the Vatican, and this idea of separation of church and state was really about taking Christianity out of the government and displacing it with satanic Roman civil law from the Vatican. All so-called court cases are actually a satanic religious ceremony by priests of Baal. Under the guise of the separation of church and state, they've taken the Lord's Prayer out of the schools, they've taken Christian symbols out of the courts, they've taken Christian symbols out of the schools, they've converted our Christian government into satanic government, and it's all been done by court rulings from priests of Baal masquerading as judges. At common law, there's no prisons. That's why common law is so severe. It's got to be settled right now. All prisons are commercial. Most of the people in prisons are there for victimless crimes. We need to fire the whores and end the tyranny of these de facto United Nations courts and their Vatican judicial whores selling their justice. Our court is only a jury of our peers, and we're all being denied it, so these judicial whores can populate their prisons and collect their royalties. We all need to work. You know, most judges retire millionaires because of the royalties they collect. We all need to work together to bring these whores to justice. I would like to see some of these whores do that little dance they do at the end of a common law rope. I am really looking forward to that. And I'm glad it's up to a jury of my peers. It's not up to me. I wouldn't want to be responsible for making that kind of decision on my own. I wouldn't have a problem participating in a jury, but just on my own, I mean, that would defeat everything I'm trying to do. That would make me worse than them. There's an organization called Life Leadership that's talking about a world shift, and it's really only 3 to 5% of the people who do anything. It's 3 to 5. It was 3 to 5% of the people who precipitated the American Revolution, and the bankster thieves and their cronies are only about 3 to 5% of the people. And historically, every 100 years, give or take, there's a major change, a world shift in our freedoms. In 1776 to 1792, there was a world shift towards freedom, and in 1913 to 1934 there was a world shift towards force, and now we're in the middle of one, quite frankly. And there's a guy by the name of Oliver DeMille that wrote a book, and he's got some good audio CD that talks about it, and so we're in the middle of a world shift, and it's going to happen, over the next maybe 10 years or so. And what they want to do is they want to provide life-changing information about what the issues are, and so that we can affect a world shift towards freedom, and and raise up leaders and people that know what the issues are and work together, and try and get 3 to 5% of the people. Actually, all we need is half of that, 1.5 to 2.5%. And they also provide a way of generating revenue through network marketing. This is their website. They call it the 8 F's. There's at the bottom: faith, family, finances, fitness, following, freedom, friends, and fun. And so they provide life-changing information on all of those categories. Following is leadership. They have CDs and DVDs that are available that cover Rascal Radio, potential constitutional changes. One that I like is Townships, Leadership Development. When I was working at U.S. Airways, they made a leadership training available for me, and I took advantage of that. And this is the same kind of training that these guys provide, and so it's self-improvement information, life-changing information that no matter what is going to change your life forever. And it's excellent material, and it's very reasonably priced. And so some of the things also they talk about is financial fitness, adversity, success, and you got to have balance. You cannot be just focused on one thing. You got to, you got to have, your family's important, spiritual issues are important, financial, it's all, you got to have a balance. They do not just sign you up and leave you on your own. They even say that you're in business for yourself and not by yourself. They need you to be successful so you can have influence and be a leader. And they need 3 to 5% of the people as leaders so we can work together and affect a world shift towards freedom. And they have meetings every night, and Tuesday night in DFW at the Omni Hotel on the Lunar Road exit, I-635 off the George Bush Toll Road, near the east of the George Bush Toll Road. There's other leadings. You can contact me. This is my Life Leadership website if you want to go there and check it out. Judgment Day's coming for these Canada Border Services Agency pigs and their judicial whore pigs. They're clerks masquerading as a judicial whore, and I'm looking forward to it. I'm looking forward to seeing some of them do that little dance they do at the end of a common law rope. And there's common law courts springing up all over, and these judicial whores are going to be brought to some real justice. And I'm glad it's not up to me. Upcoming events: corruption in the courts. 4, taxes. Did you consent? Pursuit of happiness, which is the compensation for labor. Fire the United Nations judicial whores in Texas. Fire the United Nations judicial whores in America. City of Fort Worth pigs. City of Grand Prairie pigs. Copies of these documents can be found in my Yahoo group, Administrating Your Public Servants. I have Yahoo videos, other videos, and if you do a search, my profile, YouTube profile, is Sovereign Living, and I've got I got like over 130 videos. So I would encourage you to watch the other ones and like them if you want, and subscribe, and you'll get notified when there's a new video. And if you want copies of any of the documents or the court citations that I submit in here, you can send me an email to this email address. All bar members are foreign agents of the Crown and the Vatican, as described in the presentation about bar members. The Crown is a corporation that's owned and operated by the Vatican, as found in the presentation about bar members, and about bankrupt corporate governments. When injustice becomes law, then resistance becomes duty. And that's a quote by Thomas Jefferson. I appreciate you taking the time to listen to my little rant today, and I hope you have a real nice day.